Today we are discussing about one of the most misunderstood areas of military service law in India, the disability pension for armed forces personnel, and why so many veterans lose out on benefits they are legally entitled to. Hello friends, I am Advocate Sudhi Patra, practicing in the Supreme Court of India and the Calcutta High Court. For decades, the military establishment treated disability pension as an act of administrative grace rather than an earned right. That has fundamentally changed. Today, disability pension is recognized as a vested property right protected under Article 300A of the Constitution of India. The framework rests primarily on the pension regulations for the Army and the entitlement rules for casualty pensionary awards. Under Regulation 48 and 173, the pension is composed of two elements: the service element based on rank and length of service, and the disability element based on the accepted percentage of disablement. Critically, there is no minimum qualifying service requirement to earn the disability element. A soldier medically invalided out after just a few months of service is still entitled to both elements, provided the disability is attributable to or aggravated by military service. The most contested battleground in these cases is attributability, whether a disease or injury is genuinely connected to military service. For clinical diseases such as hypertension, diabetes, psychiatric conditions, or even certain cancers, the law places the burden of proof on the military, not the soldier. This is built on a series of protective presumptions under the Entitlement Rules, the Presumption of Soundness under Rule 5, which assumes a recruit was medically fit at enrollment if no defect was recorded, the deterioration presumption under Rule 14b, which presumes any later health decline arose from service, and the shifted onus under Rule 9, which requires the military to produce cogent, recorded scientific evidence to rebut these presumptions. The Supreme Court's landmark ruling in Dharamvir Singh versus Union of India and its later reaffirmation in Union of India versus Rajbir Singh made clear that a medical board cannot simply write vague phrases like lifestyle disorder or onset in a peace station. Such conclusionary remarks are legally insufficient to deny a pension. For physical injuries, the test is different, and it turns on whether the soldier was genuinely on duty at the time. Injuries sustained during combat, unit organized training, or while traveling to and from an authorized leave station are treated as fully attributable to service, following the precedent in Madan Singh Shekhawat versus Union of India. But purely private, domestic activities such as repairing a relative's house or running a personal errand sever that causal connection. As the Supreme Court clarified in the Secretary, Government of India versus Dharamvir Singh. Alongside attributability, the doctrine of broadbanding plays a crucial role in the actual pension amount. Any disability assessed below 50% is rounded up to 50%. Disability between 50% and 75% is rounded to 75%, and anything from 76% to 100% is rounded to the full 100%. Following Union of India v. Ramaftar, this benefit now applies uniformly to every mode of exit medical invalidation, voluntary retirement, or superannuation, not just those invalided out prematurely. Perhaps the most significant recent development is the Supreme Court's 2026 ruling in Union of India versus SGT Girish Kumar, which struck down the practice of capping disability pension arrears to 3 years. The court held that because the right to broadbanded pension was already settled as a judgment in rem in Ramaftar, restricting arrears violates the constitutional protection under Article 300A, entitling eligible veterans to full retrospective arrears with 6% annual interest. For anyone whose claim has been rejected, underassessed, or restricted, the structured remedy is to first challenge an unreasoned medical board finding, exhaust the statutory first and second appeals, and then file an original application under Section 14 of the Armed Forces Tribunal Act before the appropriate regional bench, a process where correct documentation and legal framing make all the difference between a rejected claim and a fully restored pension with arrears.